Hello, everyone. Happy Wednesday. Hi, everybody. Come on in, come on in, come on in, come on in. Hi, everyone. Good evening. Hi, Mr. Stanley. How are you? Good evening. Good evening. Let me start Facebook and YouTube. Hey, Miss Joy. How you doing? Hello, 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 everyone. Hello, YouTube, Facebook, and Instagram family. Come on in. Come on in. Come on in. Come on in. Hi, Hadnan Hamed. I hope I'm saying your name correctly. Good to know you're good. How have you been, Mr. Stanley? I see you too. How you doing? Hello, everyone. Hello, Jen. Hello, Hello, Larry. Um, Thank you, Mr. Jen. How you doing today? Come on in. Say hello. So I'm on Instagram, Facebook, and YouTube. If you know anyone who want to talk about why your delayed immigration court date may be beneficial to you. So if you know anyone who will benefit from that topic, you may want to invite them in and share the video with them and let them come in. And if you have questions, gotta study with my kid. So let's see, 6:23. Okay. We'll try to get to everyone's questions that you may have. This is Attorney Abisola Olale, immigration lawyer. Great to know you're fine, Mr. Jane. Hey Simon, how are you? Hello, AOS. This is true. Abisola Olale Samuel. Immigration lawyer. My office is based, and we get that question every day. My office is based in Alabama, good old Alabama. But as far as immigration cases are concerned, I can actually represent immigration clients regardless of the state you live in. So wherever you live doesn't matter. Whoa, boy. Good evening, good afternoon. I think it's evening everywhere now. Good afternoon, though. If we can help you with immigration case, just contact our office. Our number is on YouTube and Facebook. You can see that scrolling across the screen. 334-341-4475. On Instagram, I still don't have a streaming app. Someone told me about Lula or something, like I haven't looked into it yet. I ain't got the time to do that. But the app does just fine. But if you need to contact us, our number is 334-341-4475. Okay, so let's get right into it. How's everybody's day been? So we are having a cold wave down south. Like, hey, Mr. Sunny, how are you? We are having a cold wave because we call the Alabama weather. It's Mississippi West Alabama weather, eccentric weather, because you can start. And I think someone told me in Texas they have the same craziness. You can start out in the morning in low 20s. By lunchtime, you're taking your jacket off. It's like summer. And and then it could rain, and then it's crazy. So, but this week has been rather cold. This week has been rather cold. Um, don't know why. But anyway, let's talk about, and once again, our number is 334-341-4475. Good to know you're fine, Mr. Sunny. Email is aos@olalayalawfirm.com. Contact us through the website as well, olalayalawfirm.com. So let's talk immigration. And we got another green card approved today. You have no idea how. So the funny thing is, my client, now everyone's case is different. I always say, but I like to give you a timeline of each person's case. This was the parent of a citizen. I have cases that we filed with parents of citizens that are still pending. But, the thing about their case is he had filed, son had filed for mother, and I think 3 times, and he had been rejected. And so that was frustrating to them, because if someone told them, hey, you don't need a lawyer, you can do it yourself, yada, yada, yada. So they finally contacted me, and I was like, you know what? Okay, let's just see what's going on, and do it the right way. And so I took over the case, which, basically started the case because they had been rejected. There was some paperwork that they had that wasn't going to be sufficient. And I said, okay, listen, this probably is going to be a problem, whatever the case may be. But they had already, because she came in on visa, and she had already, she had already filed an application to extend her status. And, but we were able to take care of all the paperwork that wasn't up to par and get rid of the reason why it was being rejected to start with. And just seamlessly, I got a text from them saying, listen, I don't know what you did, but I can't stop singing your praises, because you just took a whole load off my shoulders, and, they were just getting frustrated. So I think the application was submitted in May 2021, and they live in Indiana. So if that puts things in perspective. And so bam, 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 no RFEs. Well, one RFE to correct a document, a birth certificate. But the funny thing is, the extension of status, extension of the visa is still pending. The 539 form is still pending, and her green card has been approved. That's USCIS for you. But, another celebration, another client, always a good thing to help people out and make it, look effortless, but ain't effortless. It's just what God has decided to use me for. But anyway, let's talk this evening about advantage of having a later court date. What is the advantage of having a later court date? And like I said, if you've got questions, put them in the comment section, and we will go through your questions if we have enough time to do so. But what is the advantage of having a later court date? So basically, I'm talking about, if you're someone, or someone who is in removal proceedings, this will be more beneficial to you. So basically, the court date, meaning immigration court. You have been issued a notice to appear in immigration court because somehow either you had an asylum case that you filed affirmatively, and they usually say it's not denied. They say we did not find your evidence credible, and this is not a denial. I roll my eyes. So we're referring to immigration court. You get another chance to present your case, but basically you're being placed in removal proceedings. That's the truth of the matter. So either that, or you had a case, EOS case denied. You had some kind of petition denied, and then you were issued a notice to appear, which is the first thing you would get in order for the EOIR, immigration court, to have jurisdiction over your case. Then your notice to appear would generally have a date that you have to appear for your master calendar hearing, which is the first hearing you would have in immigration court. It would have the judge's name, and it will have the time and date, time, date, whatever the case may be. Now, we are having quite a number, like I think I had 3 cases that were scheduled, 2 this month, 1 next month, but they've all been rescheduled. The earliest being July, I think, is the earliest. There's some cases that they cancel the court date, but they have not rescheduled the court date. So this only current thing is changing a lot of stuff. 1 second, Mr. Simon, and I will get to you. So that's just changing a lot of stuff for a lot of people. But with the court system, immigration court system, they have rescheduled. If you are non-detained and don't have representation, I believe, or the other way around, then it's going to be your court date is going to be rescheduled or something like that. But the thing is, I have some people who've consulted with me that I'm not representing them yet. And I have cases that I'm representing people, but in both situations, the cases have been continued. Like all court dates that I have on my caseload have all been continued. But if you are detained, and those hearings will go on as scheduled. Now, I have a couple of clients who say, why did they cancel my court date, or why did they reschedule my court date? I'm looking at my hair; it's really, really gray. Does my hair really come out that gray? Now, I'm not complaining, but I was like, what the hell? Okay, I digress. I told you already, I have attention span of a 2-year-old. Like my 11-year-old and I would have the same attention span. Hello, Mr. West. We are doing fine. How are you and my boy doing? You're going to get back with me on Friday, right? As agreed. So what will be the advantage of you having your court date being delayed? Because I have a hearing that is set for 2024. And so that's the client that says, okay, what's going on? And I said, listen, the advantage mainly is this. In order for you, so you're in immigration court, basically you have one leg in and one leg out. That's the whole thing. That's the bottom line. Directly, that's what it is. You have been ordered deportable, removable from the country. Because of due process, constitutional right that's given to even non-immigrants, you cannot just be put on the plane with, there's a whole lot that went on a couple months ago with the U.S. government, but, I digress. But generally, you can't just be put on the plane and told, get out. You have a due process right to go before a judge and say, hey, this is why I should not be removed from the country. That's the whole gist in a sentence, whole gist about immigration court, right? So you have to present. I didn't say what, I don't know what you said instead of 10 years, but I'll go back to that. You have to present your basis, your defense to removability. You can, when you get your notice to appear, you have to either, master calendar hearing is for you to enter your pleadings. You can do that. In some cases, the court has ordered that I do that, filed written pleadings. So rather than come in person, we have filed written pleadings as far as whether we're going to admit or deny or concede to removability, but this is the ground for relief. And so you will have to present what your defense to being removed is. And reliefs can include asylum, application for green card, cancellation removal, VA cancellation and removal, let's say withholding of removal. What else is there? 42B, that takes care of cancellation removal. So if you are, for instance, the advantage of delayed court date is it gives you time to prepare your case and to prepare your application for relief, to also have your supporting documents that you will send to the court and file with the court in anticipation of your individual hearing date when you would have your date in court, and to be able to present your defense to the charge of being removable. If you don't have enough time to prepare, then what you're going to do, you're going to wait for an appeal. If you can, by all means, avoid an appeal, that's in your best interest. So an example would be, and I'll give you the example of the case that I have that's now been rescheduled to 2024. My client's case was denied when they filed affirmative adjustment of status. His spouse decided to use the immigration process to control him. Did not show up for the first interview, showed up for the second interview, and literally told the officer that she's done with him. She believes he's just using her for a green card. And he got his notice to appear in the immigration court less than a month after that. People are mean. Yeah. And so based on my consultation with him, he was a classic case of VA. However, he's now in removal proceedings. That means that we cannot affirmatively file a 485 with USCIS, although we can still file the I-360 petition because USCIS retains jurisdiction for the I-360 petition itself. Unlike most VA cases where I can file an adjustment of status so someone can get work permit, you have to do one at a time, because now he's been placed in immigration court. He already has a notice of appeal that was not effective. So EOR has jurisdiction over any application for relief. Now, we have sent the VAL petition in. We're still waiting for a prima facie determination to be released. We had a court date that was set for later this year. And so I'm thinking, okay, yeah, we'll get it before then, hopefully, right? So the plan is to use that to ask for prosecutorial discretion. If the ICE attorney's office would join in a motion to terminate his proceedings before immigration court and just let him deal with everything with USCIS. Now, I was a bit apprehensive about the time frame we had, because, you know, we've given a scheduled order to file application for relief and all that. But if I had the prima facie determination, that is my basis of asking for prosecutorial discretion. Now that his court date has been pushed back 2 years from now, that means that we have additional 2 years, which will give enough time within based on the processing times, hopefully no RFEs, but to give us enough time for the VAL petition itself to be adjudicated. We can go ahead and file the 485 EOR 485 with the court as application for relief, especially if if you're someone who wants to work. But knowing that you don't have a court date, of having that anxiety that, okay, you're going to be having an individual hearing and presenting your case, my petition is not being approved, then what is the basis for my 485 before the immigration court? What is the basis I'm asking the court to adjust status when I don't have anything that's been approved yet? So with the delay in the court date now, we can breathe a little bit, much easier, and know that there's going to be enough time to get closer to the petition being approved. Once the VAL petition is approved, if it's approved, so this was filed last year, hopefully it's going to will be approved later this year, next year, well in advance of 2024. Upon approval of that petition, we can file an application for relief, if we haven't done so at that time, for him to apply for adjustment of status before the court, if we don't have prosecutorial discretion to terminate proceedings and let him deal with USCIS. So bottom line is, if you do not have an airtight case yet, that will be your defense as far as what relief you're asking for in immigration court. You cannot hear me? Hello? Can someone tell me on Instagram and Facebook, YouTube, can you hear me or no? No? Okay, am I no audio? Okay. All right. So what about perfect, Facebook? Thank you. So if you don't have a well-packaged defense yet, there's no hurry. Another case is if you're in a situation where you got married while you are in immigration removal proceedings. Now you have an I-130 that's been filed on your behalf. It's pending before USCIS, and you and your spouse have to attend an interview for the bona fide exemption I-130 interview. It's always in your best interest to have that interview done, have your I-130 approved, and then go to court with that approval and say, hey, this is my basis for application for relief. I have an I-130 that's now been approved, and so I'm applying for adjustment of status before the court. You have a short hearing, and all things being equal, God being there, you have your 485 approved before the immigration court. So rushing into a court date, you've got to make sure you have something you're rushing into. If you don't have your case put together and ready to defend yourself against being removed from the country and leaving your loved ones behind, what are you rushing for? So there is the advantage of having a later court date, especially now. It gives time to whatever underlying petition that may be the basis for your application for relief in court. If you have an asylum case, for instance, you have the opportunity to amend your application. So that means you can file additional supporting evidence. If you haven't done a psychological evaluation before, you can do that. and you would have enough time before your individual hearing to be able to file your paperwork and file your evidence with the court in anticipation of your court date. And another thing is this: if you're someone who has in place, who's in immigration court based on a denial of your asylum before USCIS office, and then you get married, right? If you have your I-130 approved, then before your asylum hearing, you can actually file another application for relief, which would be adjustment of status, and that will be your basis to adjust status, and you can forget about the asylum case. So there are a lot of advantages to not rushing and taking advantage of, no pun intended, of the what's going on now, meaning cases are being pushed back, so that you use that time to actually build your case and know exactly what you're going to be asking, what your relief will be in the immigration court. Okay, let me go and get questions. So Simon on Facebook, let me put it up. Now get to, can you take up a valid case? I have it filed since 2019, although it's been handled by an attorney, but I feel it's taking time. What do you think is going on? Do you think we should change an attorney? It's 2 years and 5 months. I cannot speak to your specific case. That is something that would require a consultation. But what I can tell you generally is, if there's no issues with your attorney, only issue you're having, unless you just want to change attorneys. But if the only issue you're having is because of the time frame, 2 years and 5 months, keep in mind the question, I don't know anything about your case. Have you received RFEs? If you received RFEs, how quickly were those responded to? Because keep in mind, RFEs actually pause your case. So without knowing what 2 years and 5 months is not unusual as far as a valid petition. So if you go to uscis.gov/processing times, then you would have, you can see how long it's taking them to work in valid cases. Sometimes they're pushing forward, sometimes they're regressing. It just depends. So, but I can't speak to your specific case because I don't know anything about your case to know what's going on in your case. Okay, let's see. Perfect, Mr. Michael. Okay, so let me go on Instagram. Let's go. Give me 1 second. Scroll all the way back. All the way back. Hi. Okay, you good? Okay. Let's see. Everybody just said. So official Abby. Sounds like I'm calling myself. Official Abby, was that something you had written before you said, because I just see instead of 10 years, what does that mean? I'm not really sure what you mean by that. Hello, Mr. Jimmy. How are you? Let's see. Okay. You can hear me. All right. Instagram. Okay, perfect. I think that was just Mr. Sunny having that. Okay, let me see. All right. Okay, someone has a question on YouTube. Okay. I had my interview in September and everything went well. We're separated. Just going to recommend us for approval. Got my EAD in December, but nothing. September is how many months ago? 4 months now. October, November, December. Are you, so when you say separated, I'm thinking this is marriage based, right? Regarding my green card, thank you. So I'm a Black. It's a marriage base. Okay. I'll just say reach out to them and do an e-service request and follow up on your case and letting them know you want to get an update because you've had your interview. It's 4 months now, 120 days have passed by, and you were told you were going to get some information. That's what they always say, but you gotta wait. But the truth is, for the most part, you got to be proactive in your case. Sometimes they're doing what they're supposed to do, but for the most part, you probably wouldn't have to follow up with your case. And I have a lot, God knows how many cases I'm follow up with now. So I cannot speak to what's going on in your case. I wasn't there for your interview, so you are in a better position to file an e-service request, or if you have to do an ombudsman inquiry, to get the next level, look into what's going on with your case and why there hasn't been a decision made yet. Can you work when you file VA? So it will depend on if you qualify for a C9 work permit, which is the category that you would have to file and file an I-845 with it if you want to be able to work while your VA is pending. But just, can you work when you file for VA? You must have work authorization, obviously. So the question is, which one can you get and when? Marriage base. Okay, so that's what you would have to do. Thank you. I love hearing you speak. I'm looking to working with you when I finish your master's and applying for EP2. I'm looking forward to helping you. That's another area of practice that I love, employment based. I think I have right now. We have, I don't know. I gotta look at me. I just enjoy it. But I'm looking forward to that as well. Okay. Listen, my beautiful ring. I'm home, so I don't have it on today because I'm working from home today. I just have, usually when I'm working from home, just have a very simple face, my glasses, earrings, and nothing. Yeah, because for the most part, today I've made spaghetti for my kids. Chris made eggs. I've done laundry. Listen, I'm like I always say, I'm a mom first. Then I'm in my spare time. I practice law. So that's why you'll see tomorrow. Hello. News, is it newest next events? How are you doing? Okay, so thanks for the good explanation in this. You absolutely, the more you know, knowledge is power. So you have an attorney in the case, yes, but nobody knows everything. I learn from my clients too. Some clients get updates before I do, so there's nothing I don't take in. I don't. It doesn't faze me anyway because I'm someone who loves to learn. Now, if you want to be a smart mouth or just be disrespectful, I'll just fire you. I'll give you a warning first, but we all learn together. That's it. Listen, whoever wants to be an attorney, I have a couple of attorneys that I mentor. Um, they reached out to me. Didn't know them, whatever way I can bless people, I do. Now I don't always have the time to do that. Like I had to tell another person I can't do that. I have too much on my plate. But there's enough lesson for all of us in this world. And I'm a firm believer of one thing. People can try to steal what is yours. People can try to steal what you're, but they can't. Emphasis on try. But no one can ever take what doesn't belong to them. Your blessings will always find you. And it is a blessing in you blessing others. Like I'm the kind of person, if I'm having a bad day, my way of feeling better is looking for someone to bless. Just even if it's just a kid that I give something to or buy lunch for someone. It makes me, that's how I can deal with whatever is going on. And I just know that people may think they're stalling your blessings and may be delayed because God is just making them feel they have some power, but they ain't getting no power. So whatever way I can encourage other people or be a blessing, I always do. Okay. How soon after AOS denial does a case go to the petition proceedings and court process, especially if an appeal was filed? So, good question. And keep in mind, an appeal does not stay immigration proceedings. A lot of people think it does. It does not. They can still, thank you, Simon. They can still issue your notice to appear in immigration court. Filing a new petition and a new LS does not stay the issuance of a notice to appear. What that does in most cases, because I've had cases like that, I contacted ICE and like, hey, this was filed before an NTA was issued. Would you join in a motion to terminate because it's a waste of government resources? But there's no time frame as far as how long after a denial is issued. I always tell people start as soon as it can, because it takes us time as well to put your case together, especially if we don't have all the documents we need. That's something you have to consider, especially if your refiler is converting or your spouse messed up your interview and now you have to file for it. You have to, so the earlier you start, the better, but there's no time frame. I've had cases where it was denied, like the case I just said, the wife said during the interview that it was fraud, and less than 30 days after he got an NTA. And I'm working cases where their denial was like 2018 and nothing was issued. So it just depends. There's no time frame. There is a possibility of in every case, but the one thing you should always do is go on the EOIR case status website, put in your alien number. That way you would know if there's anything that's been issued, even if you haven't received it, if anything has been issued to you, under your alien number. But if you have a relief, start it as soon as you can. Does the location you file affect your VAWA petition? VAWA petition is filed in one place, so it doesn't matter what state you live. VAWA petition is filed with Vermont Service Center. How long your VAWA is processed? I've already answered this question. You actually asked this question, Ningy Greedy, last time. So check previous videos or go on Preston Times. Is it a must I'll live with my spouse before we submit I-130? Shared residency is a requirement. Hey, BJ Jumping, shared residency is a requirement. It's not explicitly stated, but it is a requirement of marriage base. If you're not living your spouse, you've got to show good faith marriage. Why are you not living together? Are you working in another state? Do you not come home every weekend? It's got to have a justifiable, reasonable explanation. So, but obviously that's why they make unannounced visits to your house to see if you're actually, you can't all the time live in another state and your spouse living in another state and call that a marriage for immigrant. You just cannot get away with that unless you have a justifiable explanation of why that is. Thank you. Yeah, she works in different state. Okay. All right, people. You're welcome. So once again, if we can help you with your immigration case, contact our office, 334-341-4475, and we will be able to get you started. And be able to, I always say, listen, I had a consultation today that was really, really heartbreaking. Try to detach emotions, but some cases just hit you real hard. And this lady has been through hell and is still able to live to tell it. Like, I don't think I've heard anything as far as abuse as what she's been through. And I told her, like, listen, I cannot guarantee an outcome. I just cannot. But the one thing I can guarantee, and those who are my clients to tell you that your case is important to me. And I'm working the journey with you. We're doing it hand in hand. So it's not a case of, yeah, you just pay me for a service and no. Because if you succeed, then I succeed. If you can live freely and move on with your life in the United States, that's my reward right there, beyond how much you can pay me. You can put a value in that. So anyway, whatever we can help you with your immigration case, thank you, Simon. Let us know, and we will be glad to work with you and walk with you as well in your immigration journey. Please subscribe to our YouTube channel if you have not done so. Follow us on TikTok, Instagram, share, like, and follow our Facebook page. That'll be very much appreciated.